the same lawsuit twice. Once there has been a final decision on the merits. For example, suppose you get in a car accident and you sue the other driver for negligence. A judge or jury then decides that the other driver was not negligent. You're obviously upset, but you can't just sue the other driver again for the same thing in the same or different court because you didn't like the result. Why do we have the doctrine of res judicata? How about Bryant Bernstein? You didn't give me pronunciations.
Yeah, right here.
Why do we have the doctrine of res judicata?
To promote judicial economy, right? So you can't keep relitigating things. It's a waste of time. It's a waste of money. It's a waste of resources. I'm really nervous talking.
Well, to reduce the number of lawsuits in a court.
Correct.
Less numbers of lawsuits. Collateral estoppel is the idea of specific issues litigated and decided in a lawsuit are binding and shouldn't be re-argued in the courts. With res judicata, you're saying we don't want to re-argue an entire case or a legal claim like a car accident on a certain date with collateral estoppel. You're saying we don't want to re-argue specific issues. With these ideas in mind, let's turn to the last case for you to know in civil procedure, Hiller versus Sturgill. What happened in this case? Jonathan Braun. Is that how it's pronounced?
Wrong. You here?
Is he here today?
Try another one more.
Not here?
No, not here. Not here.
We'll report him to the principal.
Jonathan Bisler.
I'm sorry, can you repeat the question?
What happened in this case?
The petitioner filed a lawsuit under the Freedom of Information Act to obtain documents relating to vintage aircrafts, and his buddy had previously filed similar lawsuit seeking the same documents. However, he was unsuccessful, and so the district court granted summary judgment for the defendants, hoping that the petition was barred by the judgment because his interest had already been litigated in the prior lawsuit. The DC Circuit Court, District Court. Okay,
Oh, no cheating.
Oh, she's holding you down.
The district court applied a particular factor test. However, on appeal, the circuit court applied their own test, and in their test there was there were two threshold factors that needed to be met, and once they were met, an additional third factor had to be met, and that circuit court found those necessary conditions to be virtual representation. Does that make sense?
Your computer's working, right?
Yes, ma'am.
If you were the attorney for Fairchild, could you try and make a res judicata argument against Taylor, the guy who filed the second lawsuit?
If I was an attorney for Fairchild,
Wait, I'm gonna call on someone else. Monica? No?
Not here.
Not here?
Call on somebody else.
A lot of absences. James Corton?
Okay. Let's see. Professor, can you repeat the question?
If you were the attorney for Fairchild, could you try and make a res judicata argument against Taylor, the guy who filed the second lawsuit?
Can you make a successful res judicata claim?
No.
Just make the argument, right?
Yeah, just make the argument.
No, because there's no mutuality to the party.
Correct.
Have him explain it, Mike.
Oh, never mind.
What?
You could try and argue a res judicata that the lawsuit has already been decided and can't be brought again, though. Right?
Yes.
Is res judicata a winning argument? How about,
Ask the same student, Mike.
okay,
Is res judicata a winning argument
For Fairchild.
for Fairchild?
okay.
I believe it is not. Because it goes back to the concept of virtual representation.
Because each person is entitled to their own day in court, right?
Yes. And it wasn't a proper virtual representation here. In this case, it wouldn't apply.
Jordan Carlson, here today? Nope. Is she hiding? Did she turn in a pass or something?
Keep going. Call on somebody else.
Clean. Darn.